All right, let's dive right in. Today, we're talking about something that seems, kind of simple and maybe a little dry, but it's actually one of the most critical pieces of our entire justice system. It's called the record of trial. Think of it as the official story of a case. But the real question is, what happens when that official story has a few pages missing?
So this trial record, you can really think of it as the court's memory. It's supposed to be this perfect word-for-word account of everything that happened. Every single piece of testimony, every ruling, all the evidence. And this level of accuracy, it isn't just a nice to have, it's the absolute foundation for a fair trial and, maybe even more importantly, a fair appeal. It's meant to be the one ultimate source of truth, but is it really?
Because that's where the problem kicks in. What happens when that official memory is faulty? When it's incomplete? Or just plain wrong? And listen, this isn't some rare hypothetical scenario. It's a constant issue that can and does throw a major wrench right into the gears of justice. This really gets to the heart of it. On one hand, you've got the ideal, right? This perfect, pristine record that's supposed to be the ultimate source of truth. But then, there's the reality. A flawed memory, riddled with gaps, errors, and missing arguments. And what that means is the very document designed to guarantee fairness often becomes a major source of conflict when a case goes to appeal. So, you might be wondering, where do all these gaps even come from? Well, a huge reason is that oral arguments, the moments when lawyers are debating points of law or objecting to evidence or making these crucial procedural requests, a lot of the time, those are not transcribed. Just imagine a lawyer making a brilliant, case-changing argument, and it just vanishes. Poof. It never even makes it into the official record.
And this, as you can imagine, leads to a pretty critical question. What kind of chaos does a broken record actually cause? I mean, if an appeals court is looking back at a trial full of holes, how can they possibly know what really went down?
Well, the chaos looks a lot like this. All of a sudden, an appellate court is forced to try and answer these incredibly high-stakes questions. Was that key piece of evidence just quietly agreed to, or was there a huge fight over it? Did the judge just completely ignore a crucial point a lawyer made? Was one side totally blindsided by the judge's final reasoning? You see, without a complete record, answering these questions turns into this massive, contentious puzzle. So how in the world does a court solve a puzzle like that? They don't just throw their hands up and give up. It turns out there's actually an established process for this. An appellate court has a very specific set of tools, 5 to be exact, that they can use to try and piece together what really happened. And here they are. The 5 approved sources for fixing that broken record. A court can look at the trial judge's own personal notes. They can look for an admission from one of the lawyers. They can go back to the court reporter's original tapes or shorthand. They can even hear new, sworn testimony about what was said. And then there's number 5, which is maybe the most important of all, a note taken at the time by a lawyer or someone else in the room. But I want you to notice what's not on this list. Simply taking a lawyer's word for it after the fact. That's not enough. This really strict process puts a ton of pressure directly on the trial lawyers. It all boils down to this fundamental and frankly kind of harsh principle in the legal world. If it's not on the record, it didn't happen. The responsibility is placed squarely on that lawyer's shoulders to either get it recorded or, if they can't, to write it down themselves right then and there. And that's exactly why that 5th tool, the contemporaneous note, is so vital. When you're in a fight over a flawed record, a lawyer's carefully taken real-time note can become the single most powerful piece of evidence to prove what truly happened. It can literally save a case on appeal. Okay, but just when you think you've got all the pieces of the puzzle figured out, the system has one final, fascinating little twist that makes things even more complex. Now, to understand this last part, you have to know this key legal distinction. Some documents are what's called part of the record, meaning they've been officially filed with the court, like an affidavit or a statement of claim. But that is completely different from a document being admitted into evidence. That's a formal step where the judge accepts it as actual proof of a fact in the case. So what does that mean in the real world? It means that just because a sworn affidavit is sitting there in the official court file, a judge can't actually use it to decide who's telling the truth. If that document wasn't formally handed to the judge and admitted into evidence during the trial, it's basically just a piece of paper in a folder. It has no power as proof. So that leaves us with this final thought to chew on. If the official memory of a trial, the very document that's supposed to guarantee fairness, can have so many holes, so many hidden rules, and so many twists, it really makes you wonder, doesn't it? How much of justice actually depends not on what's written down on paper, but on everything that happens just off the page.